Ready, start. Leave granted. This appeal is directed against the judgment and order dated 19/4/2006 passed by the Division Bench of the High Court of Judicature at Bombay in appeal number 198 of 2006. The Appellant Society has filed the above said appeal challenging the order dated 14/11/2005 of the learned single judge, whereby the appellant's arbitration petition number 423 of 2004, filed under Section 34 of the Arbitration and Conciliation Act 1996 against the award of the arbitral tribunal was dismissed. Briefly stated, the relevant facts are as follows. The appellant is an educational society duly registered with the Charity Commissioner, Bombay, under Bombay Public Trust Act 1956. The appellant society desired to establish a women's college at Borley, and therefore it invited tenders for construction of a building at Borley, Panchatan. The society was depending upon magnanimous donors who have agreed to donate the entire amounts for the project. The respondent company is incorporated under the Companies Act. The director of the respondent company visited the site, and in the presence of the donor they agreed to construct the building at the proposed site. The respondent company offered tender for constructing the building at a total cost of rupees 1 crore 55 lakhs 37,981 and 20 paise. The college was named after the donor as Kalsekar Institute of Science. It is the case of the Appellant Society that the tender of the respondent company was accepted with the condition that the time was essence of the contract, and the respondent company by its letter dated 29/4/2000 assured to the Appellant Society that the company will complete the project within the stipulated time. The standard agreement drafted by the Council of Architects was executed on 24/2000, and the entire project was to be completed within 18 months on or before 1/11/2001. It was also agreed that the final measurement and valuation shall be done in the 17th month. The date of the commencement was agreed upon 1/5/2000. The procedure for payment was that the respondent company would submit the bills to the appellant's architect, and the same would be forwarded to the donor, president of the appellant society, and thereafter the check issued by the donor in the name of the appellant society, and in turn the appellant society would pay the amount to the respondent company. We have gone through the general conditions of contract executed between the appellant society and the respondent company. The type of contract in terms of clause 3 of the contract was item rate contract, and the contractor was to be paid for the actual quantity of work done as measured at site at the rates quoted by him in the contract bills. In terms of clause 16(1), the architect shall be the owner's representative during the construction period, who shall periodically visit the site to familiarize himself generally with the progress and the quality of the work, and to determine in general if the work was proceeding in accordance with the contract document. As per clause 32, when any instruction or decision given at site involves an extra or whereby the contractor may plan to claim an extra, it shall be the responsibility of the contractor to inform the architect of the extra amount and get written authorization from the architect before the proceeding with the work involved. Clause 14 of the arbitration agreement stipulates that upon it becoming reasonably apparent that the progress of the works is delayed, the contractor shall forthwith give written notice of the clause of the delay to the architect, and if in the opinion of the architect the completion of the work to be or has been delayed beyond that date for completion stated in the appendix to these conditions or beyond any extended time previously fixed under this clause, stop.